Welcome back to Verdict Watch. Today we've got family ties, business drama, and some heated bond conditions on the line. Stick around. This one takes a wild turn you won't want to miss.
Public Defender Chelsea Virgil with him on behalf of Matthew Verlian. Please state your name for the record.
Matthew Verlian.
All right, you're requesting an adjournment.
Yes, there's some discovery yet to be received in this case, and I would ask to address a bond condition.
And you're asking the discovery, you did request it yesterday. So it should
Got it. Should be here soon. Okay. Probable cause conference will be adjourned June 5th, 2025, 9 a.m. Yes, Esteban.
Your Honor, we are asking to have the no contact order lifted. My client has been staying with his mother in Chelsea. He plans to continue doing so. We're not asking to have the no go-to order lifted. I think the concern in this case is that my client's family typically runs a business that the complaining witness may be involved in, and that business needs my client's help to continue running. That business is not anywhere near the complaining witness's home, from what I understand. He understands what consensual contact means and is committed to continue following his bond conditions. He hasn't been on bond long, but in the time he has been, there have not been any violations. I believe the complaining witness may be here to address the court today.
She is present today to address the court.
All right. Step back. Where is she? Ma'am, come on now. Hello.
Hi. So I own a business with Matthew's sister. And
Hold on.
Oh,
I know you were ready to start. You got to that line and just took off.
Sorry.
I need you to state your name.
Amy Phillips.
All right, now go ahead.
I own a business with Matthew's sister, and he's played a vital role in the business for the last 2 years. We're about to get into a really busy season. It's a canoe and kayak rental business. So I would like to ask to remove the no contact order so I can efficiently run our business.
All right. Okay. All right. And you think that he will cooperate with a no non-consensual contact?
I do.
All right. Thank you, ma'am.
Thank you.
Any objection?
Okay, here's a crucial moment. Lifting a no-contact order is no small ask. Judges take these seriously because it's about safety versus freedom. Will the court buy this argument? Let's find out.
From the people.
This time I would object. This case is just around 513, and I have serious concerns with this case. It involves him going to Miss Phillips' house in the middle of the night to take her phone to go through it. She wakes up, calls 911. He comes back to the house, walks in, is screaming at her. She had her foot in a doorway. He slams the door on her foot 5 times. And then she went to call 911 again. He saw her on the phone, chased her to the back of the house and tackled her while she was on the phone 911, ripping it from her, the phone from her hands and throwing it at a wall, breaking it. I just have concerns given the facts of this case. And from that, she had a contusion on her thigh, bleeding on her foot, and on the back of her foot a cut. So I just have concerns given the facts of this case and how recently this happened for any contact at this point, and would be objecting.
Anything else, Mr. Jones?
I would just say that my client and I feel strongly that he is able to
Notice the strategy here? Instead of minimizing the charges, the defense leans on practicality. The business can't run without him. It's a clever pivot, but does business need outweigh public safety? That's the million-dollar question.
comply with court orders and that there wouldn't be any further criminal activity from my client, and that the bond conditions with the no contact order lifted are sufficient to protect the complaining witness, who can revoke consent for that contact at any time.
I will grant the request. I will delete the no contact provision, having heard from the alleged victim in the case. I'll delete the no contact and add no non-consensual contact. So young man, you understand what that means, that if she doesn't want you in her presence, you must immediately leave.
Yes, Your Honor.
Understand that?
Yes, sir.
All right. With that added condition, bond will continue, or that adjustment.
Thank you, Your Honor.
Thank you.
Thank you.
Next case on the docket.
Court does call the case People versus Molly Fox.
Good afternoon, Your Honor. Ellen Dennis, appearing on behalf of Molly Fox.
Whoa! Did you catch that? Middle of the night break-in, phone smashed, victim tackled. This isn't just a business inconvenience. This is serious alleged violence. Viewers, quick poll. If you were the judge, would you allow any contact after hearing that?
Okay. What, Mr. We may have an issue. Go ahead. What are we doing on this? I am.
Says the court received a bond violation.
Oh,
Have you seen it, counsel?
yes, Your Honor, I have seen it.
She's positive for cocaine.
Right. Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely
She
unacceptable.
had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. And yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued, and if court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the second phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about.
And just like that, the no contact order is gone, replaced with a no non-consensual contact rule. Basically, if she says no, he's got to go. But here's the kicker. It puts responsibility back on the victim to enforce boundaries. Risky or reasonable, you decide.
About possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for three minor children, ages 13, 10, and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget which, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly been modified to have provide for her to have an alcohol drug tether. I might also say, I think my understanding is that she entered a recovery program voluntarily. That was not a bond condition. Is that correct?
It wasn't.
She says it was not. So she is she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry.
This is her third violation with cocaine.
Apparently so.
Yeah, that's a problem.
It is a problem, and but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she
At
understands.
what point did that dawn on her?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend because obviously it's not a friendship that's furthering her best interests. And she tells me that she is going to do that. So I hope that she has come to a realization of how damaging to herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Switching gears, now we've got a bond violation with drug use. And not just once, but multiple times. The big issue? Courts want to see progress in recovery, not repeat slip-ups. Let's see how much patience this judge has left.